Then the another case which comes is the successful enforcement effort of non-BRICS jurisdictions by the Chilean authority. The Chile is the another country which has a very good track record in the enforcement of transnational application of competition law. And here your attention is drawn to a very famous case known as FNE versus Whirlpool SA 2012. And in this case, what the Chilean authority did that it has conducted a thorough investigations. And the worth mentioning is that they have very pinpointedly identified the international refrigeration compressor cartel issue of the Whirlpool in the jurisdiction of the Chile. Thus, what we find that in 2009, that the Chilean authority was transpired by the Brazilian and the European Union and the United States, and on the strength of their investigation and underlying conduct, they have won the case and terminated all kinds of the contract of the Whirlpool case, and they brought all the perpetrators of the Whirlpool with a very heavy fine. And after a follow-up action, what we see that the Brazilian or the Chilean authority have been successful in bringing the Whirlpool, Embraco, and Tecomeshe, the relevant violator, who were responsible to an staggering 97% of the sales of the product on the Chilean market. In a way, we can say that their anti-competitive behavior have almost captured and squeezed the domestic potential of the Chilean market, and it is only on the strength of that a thorough investigation they have set a very landmark case by bringing Whirlpool company to the book by imposing a very exorbitant and exemplary fine in matters of extraterritorial application of competition law. The Competition Tribunal of the Chile explicitly recognized the effect doctrine, and if you see that what we find that the Chile is a country which have not explicitly recognized in the statute any kind of a provision relating to extraterritorial application of competition law. Here, dear learner, it is very salubrious to note that whether a country possesses a very categoric statutes or the provision relating to extraterritorial application of competition law or not, but it depends mostly on the issue that how you adopt your investigation, how you adopt your litigational strategy, and how effectively you judicially interpret the entire doctrine and principles of extraterritorial application. What happened in Whirlpool case is an eye-opener for us, that the Chilean Competition Tribunal recognized merely the effect doctrine, and then the judiciary has recognized and created a kind of a space and leeway for the anti-competitive behavior and transnational application of the competition law, and have fined the Whirlpool despite they don't have any kind of a statutory provision. But the same judgment which has been handed down by the Chilean Competition Authority, the judiciary through its interpretation of that case have upheld in 2013, and the Chilean Supreme Court can be congratulated on that count, that what has been finally concluded by the Competition Tribunal of the Chile, they have recognized the judicial doctrine of effect doctrine of US antitrust law and applied and upheld that the Whirlpool has violated the transnational application of competition law in the domestic market of the Chile. Then, dear learner, we will, after having a kind of a detailed survey of the South American jurisdiction in relation to the violation of the enforcement mechanism and the anti competition law in the context of extraterritorial application of competition law, we will try to chill out or cool out what you can say that what are the basic hurdles and hiccups in the enforcement of competition law. So, what we can say that the competition law in developing countries, particularly deficiencies in the global regulatory framework and the enforcement agencies, has been a point of simmering discontentment, and the hurdles and hiccups which existed between the enforcement of competition law domestically or transnationally needs to be identified, and we have to address the entire factors which hinders transnational enforcement. In that sense, dear learner, we have to see that some of the practical issues which has been identified in the effective enforcement, because our purpose is not where exists the transnational application of the competition law and where exists the extraterritorial application clause in the national law, or how the laws are passed best, but we see that how the laws are observed in compliance and cooperation, and in that respect we have to be very pinpointedly elaborate that what are the hurdles and hiccups. In that reference, we can say that in the enforcement regime of the extraterritorial application of competition law, what we find that there are problems of procedural rules, especially the problem that how you serve the notices to the parties, entire process of service. We have certain problems of collection of sharing evidences, because most of the evidences in various jurisdictions remains one and the same, but the problem appears that all the jurisdictions with a sense of cooperation and confidence share those evidences of a particular company who happens to be the violator at multi jurisdictions. So, the sharing of the evidences and not only the collection of the evidences is important, but sharing of those evidences are equally important in the enforcement regime of transnational application of competition law. Then we will also have some problems, and those problems are related to the non-compliance, and more than non-compliance, what we find that the issue of the non-cooperation which are exhibited by some of the countries and some of the agencies happens to be not very sensitive to that issue. They happens to be callous, sometimes lethargic in carrying out those investigation, and delay in the investigation mars the entire process of the enforcement of the extraterritorial application of the competition law. We also noted as a hurdles and hiccups that there is either there are some absence or there are insufficient existing international instrument regarding the enforcement of extraterritorial application of competition law. Vis-a-vis, we also find that there are some kind of an absence and inefficiency which are found at the different jurisdictions of the world. Either they don't have, or if they have a very feeble or ineffective mechanism of the enforcement and the execution of the decisions and the judgment, inclusive of realization of pecuniary fines and imposition of ad valorem damages, or the liquidated damages or unliquidated damages. The issue of quantification of the damages, the computation of the damages, and the collection of the fines are also very important, that how those judgments are to be carried out, how those judgments are to be well implemented in a right spirit. we have problems and hiccups and hurdles at the stages of investigation, because the investigation is a kind of a process in the enforcement of the extraterritorial application of the competition law, where there is a chain, and a chain of ratiocination is there. And if the entire chain of the enforcement, if there is some kind of a collapses between the investigation, then it has a ripple effect of disturbing the entire chain of the investigation and entire chain of the enforcement. So, as a way, we can say the effective preparation of extraterritorial enforcement requires an entire enforcement process. Holistically, we have to see that what are the applicable rules and procedural rules in a more broader and a generic sense, that what are the procedural labyrinth, the procedural ambit, the procedural scope, and each and every stage are to be well taken care of, and then only we can have some very effective enforcement and successful investigation of the cartelization and abuse of dominance or anti-competitive behavior or regulation of combination under the competition law. In this respect, dear learner, it is very salubrious and pleasant to note some of the experiences which comes from the Brazil, and the Brazilian CAD experiences are worth discussing. And in this context, what we find that the hurdles present at the onset of the investigations are particularly worrying. But what we find that they may not only hinder any enforcement action but also contribute to transnational misconduct. So any kind of misconduct in one jurisdiction have an spiraling effect or a multiplier effect in other jurisdictions. So that way the enforcement actions are something that very necessary and sine qua non of the extraterritorial application of competition law, and to arrest the pernicious tendencies and to arrest the pernicious tendency of transnational misconduct by the firms, that under the shadow of the law, that requires a thorough scrutiny, and we have to potentially find that what are the affected jurisdictions in matters of enforcement of extraterritorial application of the competition law. In that way, we can say that we have a range of experiences, we have a range of agencies, and we have a range of challenges. And in that context, again quoting from the Brazilian jurisdiction and the example of CAD, that continue to encounter those problems, and their experiences of encountering such problem despite its numerous successful investigation of international cartel. What we see that in 2017, the Brazilian competition authority reported that half of the investigations launched after 2010 were still pending notifications. So that really gives the feel that even if you have a very massive and a very labyrinth exercise or a mammoth exercise of the investigation of the anti-competitive behavior or the violation of the extraterritorial application of competition law, but we find that many things are still pending out of notifications, and unless it has been notified, then the actual enforcement and the realizations and the remedial aspect of the competition law will not be a reality. So that way, then attempts are to be done or directed to serve legal notices in abroad, which often fail, because there are certain principles that each jurisdiction has a different principle of serving the notices. In this context, we can have an example not from the South Africa, we have to go to the West Asia. And in the West Asia, the most progressive country happens to be the Turkey, now known as Turkey. They reported that they have looked into the anti-competitive pricing on the coal import, and examining that issue both in the domestic and the European Union based companies, they find that there are multiple efforts to save process abroad, and we fail not only because that we have a different kind of a mode of service, and then the domestic parties serve the sanctions and face the sanction. Thus, we see that the Turkish agencies on competition face the problem primarily on the service, be that at internal level, be that at external level, or be that at the Ministry of Justice level, or be that in the level of the Ministry of Foreign Affairs. But what we find, the example from the Colombia, that also serves a very interesting case in the case of the enforcement. We find the Colombian authorities, after opening their first transnational case and undertaking to investigate an auto part cartel, have ultimately terminated the proceeding due to both ineffective service of the process and the various procedural errors. So, in a way, what we can learn that the example of, despite that the CAD, the Brazilian competition authorities happens to be very active, very at the forefront, very vibrant, and very prodigious in that sense. But even the Brazilian CAD has reported that many of their investigation in 2017, there has been a report that those things which has been decided in 2010 are still pending for the notification. And the similar problem happens to be there is a case of notification where in Turkey there is a case of serving the notices, and in Colombia there is a case of, again, both the procedural errors which are crept into the entire process, and another way, the ineffective service of the process. These are some of the major issues which have come as a major hiccups and hurdles in relation to the transnational application or extraterritorial application of competition law in developing countries. Now, dear learner, we will try to see that what are the state practices of the European Union, what are the state practices of United States antitrust law and policy, what has been the policies of the South American countries, be that Mexico, be that Brazil, be that the Chile, or what we have the problems which are lying in the West Asian countries, especially in Turkey, or what are the problems in Colombia, what are the problems in Russian federations. What we infer out of it, that we require a kind of a very systematic reform of the procedural competition law to accelerate the entire process of the enforcement, especially in the extraterritorial application of the competition law. And unless we stem not only the hiccups and hurdles, but we have to also try to underline that the rot which has been, and that we have to stem the rot so that we can have a very expeditious and very viable and vibrant procedure which can guide and which can effectively have the enforcement of extraterritorial application of competition law. What we discuss in the context of different countries, ultimately what we can conclude at this stage, dear learner, that the procedural rule, the evidentiary rule, the service rule, the notification rule, and then actual enforcement and summoning rules are to be reformed at the earliest, so that if the cases of investigation by any national competition authorities are being taken in right earnest, and if the national competition authority have reached a particular judgment, or the judicial organ of any state have come very heavily against any firm which are indulging into the anti-competitive behavior, then we should be in a positions to enforce them And it can only be possible if we adequately pay our attention that what are the diversity of the issues right in American jurisdiction, in European jurisdiction, in Asian jurisdiction, in South African jurisdiction, in Latin American or South American jurisdiction, or West Asian jurisdiction, or the Russian federations. We have to think in a global context, and we have to think in a very holistic manner, and we have to take a very generic sense of understanding, a generic understanding of the entire enforcement procedure, so that we can reach to a very viable and amicable system of enforcement of the extraterritorial application of competition law in developed and developing countries. I hope, dear learner, you will be quite satisfied that what are the major trends, what are the tendencies, what are the problems, what are the remedies, and what are the recommendations in matters of enforcement of extraterritorial application of competition law in developed and developing countries. Thank you very much. Have a happy learning.